Welcome to the Deep Dive. We're here to help you cut through the noise and get straight to the core of complex topics using your source material as our map.
That's right.
Today, we are charting a course through the fascinating and incredibly vital legal landscape of California real estate.
It really is vital.
Yeah, if you're looking to thrive in the Golden State's dynamic market, understanding its unique rulebook isn't just important, it's the foundation. It's how you build trust and expertise.
Absolutely. California's real estate environment, it's governed by a very specific set of state laws and regulations.
Right.
And these aren't just bureaucratic hurdles,
Right.
They are the framework. They're designed to protect the public and ensure the integrity of every single transaction. For anyone aspiring to a career here or really just wanting to be truly well-informed, mastering this legal groundwork is, well, it's not negotiable.
And that's really our mission in this deep dive. We've taken your stack of sources, articles, regulatory docs, essential guidelines on California real estate law and practice, and we're going to unpack the most crucial elements. Our goal is to help you understand not just what the rules are, but why they exist and, how knowing them makes you more confident, ethical, and effective professional. Think of this as turning the legal jargon into your superpower.
A superpower, I like that. And we should probably start at the very beginning, right, with the entity that actually sets the standards and enforces all these rules.
Okay, let's unpack this then. The heart of real estate regulation in California is the Department of Real Estate, the DRE. What exactly is this agency and what's its core purpose?
So the California Department of Real Estate, the DRE, yeah, they're the state agency responsible for licensing and regulating real estate professionals. Their core mission, and it's stated really clearly in the source material, is to enforce the real estate law and the subdivided lands law.
Okay, enforcement.
Right, but with a specific goal,
Mm-hmm.
achieving maximum protection for everyone dealing with real estate licensees and also for purchasers of subdivided real property. That idea, maximum protection, it really underscores everything they do.
Maximum protection. That's a powerful phrase. It tells you right away whose interests the DRE is primarily looking out for.
Exactly.
And the head of the DRE is the real estate commissioner. What are some of the specific duties assigned to the commissioner that impact agents and, the public?
Oh, the commissioner wears many hats. They're responsible for qualifying individuals and entities for licenses. So that's salespersons and brokers, obviously.
The main ones, yeah.
But also things like mortgage loan originator endorsements, MLOs, and licenses for prepaid rental listing services, which we can touch on later. Essentially, they decide who gets to operate in this space.
So they control access to the profession. What else falls under their duties?
Well, they're also the primary enforcer. They investigate complaints filed against licensees and, pursue formal disciplinary action when rules are broken.
Okay.
And crucially, they also investigate people performing activities that require a license, but who don't actually have one. This helps protect the public from unqualified or, frankly, unscrupulous individuals operating outside the regulated system.
Yeah, that makes sense. You need to go after unlicensed activity to keep things legit.
Exactly. And beyond just the licensing and enforcement, they regulate specific types of real estate transactions. This includes the sale and lease of interests in subdivisions, dealings involving mineral, oil, and gas property, and those prepaid rental listing services we just mentioned. It's a pretty comprehensive oversight role.
Clearly, the DRE is the central hub for anyone involved in California real estate. So, okay, how does someone actually navigate the path to becoming licensed through the DRE? Let's start with the salesperson license. That's the entry point for a lot of people.
Right. The process really begins with applying for the examination. You submit a written application, pay the required fee to the DRE, and the commissioner has specific requirements for the format and content of that application, so it's really essential to follow the instructions precisely.
Can you, apply for the license itself at the same time you apply for the exam, or is it sequential?
You can. Actually, you have the option to submit both the exam application and license application concurrently. Just remember, the DRE will not actually issue the license until you successfully pass the examination.
Ah, okay.
So applying concurrently might streamline the process a bit after you pass.
Yeah.
But passing that exam is the absolute non-negotiable step before you get the license itself.
Okay, so get the paperwork in, pass the exam, then the license gets issued. What happens after you apply for the exam? How do you know when and where?
Well, once your application is approved, the DRE sends you an examination schedule notice. This is a key document. It confirms your eligibility and gives you the date, time, and location for your exam.
Right.
Our sources mention that if you apply online using their licensing system, you can often view and manage your exam schedule directly there. which is, pretty convenient.
Definitely.
And if you don't receive your notice within the DRE's stated processing time, checking a licensing or, contacting them directly is probably a good idea.
Okay. And what if something changes after you submit the application, but before the license comes through? Like maybe your address changes.
Yeah, good question. The sources note that the commissioner has the discretion to require you to submit a supplement to your application to update that information. It's really crucial to keep the DRE informed of any material changes. Honesty and accuracy, they're assessed from the very start of the process.
That makes perfect sense. Always keep your records current with the regulator. Now let's talk about the broker license. That's a step up, right? It requires more experience or education.
It does, yeah. The most common path to qualify for a broker license is by demonstrating at least 2 years of full-time experience as a licensed real estate salesperson in California. And that experience needs to be within the immediately preceding 5 years.
2 years full-time in the last 5? How do they check that?
The DRE is pretty specific about how this experience is verified. Typically, it's through an employment verification form, the RE-226, which is completed by your employing broker or brokers.
What if you had an employing broker who maybe isn't around anymore or just isn't willing to sign that form? Is there another way to prove your experience?
Yes, thankfully there is. The sources mention you can use an employment certification form. Instead, that's the RE-228. With this form, you need to have your experience corroborated by at least 2 other individuals.
Okay.
These individuals need to have been active in related real estate fields, like maybe escrow, title, or lending. And they need to have been in a position to actually verify your duties and the dates you were employed as a salesperson.
So people who knew you were working as an agent.
Exactly. And you'd also need to include a written explanation to the DRE detailing why you couldn't get the verification directly from your employing broker. It's a necessary step just to ensure your claimed experience is legitimate.
That's a really valuable alternative to know about. What about education? Can a college degree help someone meet the broker requirements?
Absolutely.
Yeah.
A 4-year degree from an accredited university or college, that, combined with completing the specific real estate courses required by the DRE, can actually substitute for that 2-year experience requirement.
Oh, interesting. So a degree can replace the experience.
It can, but you still need the specific required real estate courses, and those courses must be completed at an institution that's either accredited or has had its real estate courses formally approved by the DRE.
So degree plus the required courses can get you there without the 2 years of salesperson experience. Can you mix and match? Like combine some experience and some education?
Yes, you can. The DRE recognizes that people come from different backgrounds. The sources indicate you can often combine a certain amount of salesperson experience with education or maybe experience in related real estate fields to meet the broker qualification standards. It's not just one rigid path.
That's good flexibility.
Yeah, for example, someone with maybe 1 year of salesperson experience might be able to combine that with other real estate related work and specific college courses. You need to detail all of this very clearly on your application, of course.
Right. For the broker license exam and the application itself, is there a combined option like there is for the salesperson license?
Yes, there is. You can submit one application that covers both the broker exam and the license. This is called the broker exam license application.
Okay.
With this, you submit all your required education and experience documentation right up front, along with the application and the fees. Now, key point here. You have 2 years from the date the DRE receives this combined application to successfully pass the broker examination.
2 years to pass. What happens if you don't?
If you don't pass within those 2 years, the application expires, and unfortunately the fees are lost. You'd have to start over.
2 years to pass the broker exam once your application is filed. It's good to know there's a deadline. Are there any specific requirements for broker applicants who don't already hold a salesperson license when they apply? Maybe they qualified through education only?
Yes, there are. If you're applying for a broker license without first holding a California salesperson license, you'll need to include a completed state public benefits statement, Form RE-205, and you also need to provide proof of legal presence in the U.S., like a copy of your birth certificate or passport, with your application.
Okay, extra steps for those coming straight to the broker license. Now, let's talk about brokers operating under a business name. Lots of brokers use something other than their own name, right? Like Golden State Realty or Sunset Properties. That needs a specific process with the DRE, doesn't it?
It absolutely does. If a broker, whether they're an individual or a corporation, wants to operate under a name that's different from the one on their actual DRE license, they first have to get a license issued by the DRE bearing that fictitious business name. You often hear it called a DBA, or doing business as.
Okay, so you need the DRE's okay on the name. How do you get that?
There's a specific sequence of steps. First, you have to file a fictitious business name statement, an FBNS, with the county clerk in the county where the broker's main place of business is located. And the broker must be listed as the registrant on that FBNS.
File with the county first, then what?
Once that's filed, you need to get proof, usually a certified copy showing it's been filed. Then you forward that certified copy of the filed FBNS to the DRE.
Along with?
Along with the appropriate DRE change application, there's a specific one for individual brokers, RE204A, and another for corporate brokers, RE203, and you pay the required fee. The DRE reviews this, and if everything's in order, they'll issue a new license or update the existing one to include that approved fictitious business name.
So this sequence is crucial. File with the county, get the proof, then apply to the DRE with the county proof and the correct DRE form.
Exactly. The DRE license has to reflect that DBA before you can legally use it in any of your licensed activities. And the sources also clarify something useful. Adding a DBA to a broker's license doesn't require any changes to the licenses of the salespersons working under that broker. Their licenses stay as they are.
That's a good point. Saves some hassle for the agents. What about corporations? Can a whole company get a real estate license?
Yes, absolutely. A corporation can be licensed as a real estate broker in California. The main requirement is that at least one officer of the corporation must be a duly qualified real estate broker who's willing to serve as the corporation's responsible designated broker officer.
Responsible designated broker officer. What does that mean?
That individual is the one who's ultimately responsible to the DRE for the actions of the corporation and all its licensed employees. They're the license point person for the corporation.
Got it. So a licensed broker has to be that designated officer. What does the corporation itself need to submit to the DRE?
The corporation needs to submit the appropriate corporation license application, pay the required fee, of course, and provide a certificate of status from the California Secretary of State.
Certificate of status. What does that show?
It confirms the corporation's active legal status in California. And it needs to be pretty current issued within 30 days before the date the DRE receives the license application.
Okay, so the corporation needs to be in good standing with the state, confirmed recently, plus have that designated individual broker officer.
Precisely. That covers the corporate structure.
Now, shifting gears slightly within this licensing world, let's talk about mortgage loan originators, or MLOs. The sources mention something called the SAFE Act. What is that, and how does it affect California real estate licensees?
Right, the SAFE Act. It stands for Secure and Fair Enforcement for Mortgage Licensing Act. It's actually a federal law. Its main goal was to enhance consumer protection and reduce fraud by setting up minimum standards for licensing and registration of state-licensed mortgage loan originators.
Okay, federal standards. How did California implement that?
California aligned with this by requiring real estate licensees who want to actually originate mortgage loans to obtain an MLO license endorsement.
So it's an endorsement on your existing real estate license, not like a totally separate license you have to get from scratch.
That's correct. It's an add-on authorization to your real estate broker or salesperson license. And the requirements to get this MLO endorsement are pretty specific.
Like what?
You need to pass the National SAFE Test, which includes uniform state content. You have to submit an electronic application for the MLO endorsement through the nationwide multi-state licensing system and registry, everyone calls it NMLS, using their form MU4, and pay the necessary fees through NMLS.
Okay, NMLS is the system for this. What else?
You also provide fingerprints through NMLS for background checks, complete at least 20 hours of approved pre-license education through an NMLS-approved provider, and you have to authorize NMLS to pull your credit report.
Wow, that's quite a checklist just for the endorsement. What about keeping it active? The continuing education for the MLO endorsement is at the same CE you need for your regular real estate license.
No, and this is a really crucial distinction the sources highlight. They're totally separate. The MLO endorsement operates on a calendar year basis, so it expires on December 31st every single year.
Every year.
Yep. To renew it, you have to file through NMLS, pay a renewal fee, and complete 8 hours of continuing education specifically approved through NMLS for MLOs. And this 8 hours of MLO-CE cannot be used to satisfy the separate CE requirements for your standard California real estate license, which is typically 45 hours every 4 years.
Okay, so 8 hours MLO through NMLS every single year, completely separate from your regular 45 hours for your RE license renewal. That is vital not to mix up.
Absolutely critical.
Speaking of CE in general, the sources mention that the courses and the providers themselves need DRE approval, right?
Yes, that's true for both general real estate continuing education and for those MLO-specific courses. The education providers and the courses they offer have to be reviewed and approved by the commissioner. And for the MLO courses, they also need that NMLS approval. It's all about ensuring the quality and relevance of the education licensees are receiving.
Makes sense. Quality control. Now, what about renewing your main real estate license? The salesperson or broker license. What's the typical process and what happens if you mess up and let it expire?
Well, the standard renewal process is pretty straightforward. You submit your renewal application and complete all your required continuing education before your license expiration date. Pay the fee, obviously.
But if you miss that deadline,
If you miss the deadline, the sources explain you can still apply for a late renewal, but only within 2 years from the expiration date. This involves submitting the proper application, providing evidence that you've completed the current CE requirements, not the ones from when your license expired, but the ones required now, and paying a late renewal fee, which is higher.
so you can renew late, but it sounds like there's a pretty significant catch.
There's a huge catch. You absolutely cannot perform any activities requiring a real estate license from the moment your license expires until the date it is officially renewed and shows as active in the DRE system.
None. No showings, no contracts.
Nothing that requires a license. And you cannot claim a commission for any services you performed during that period when your license was expired.
Yeah.
Any deals closed during that lapse, you likely can't get paid for them legally.
Ouch. That's a massive financial risk if you aren't super careful about your renewal date and CV completion.
It really is. Procrastination can be very expensive.
What about that conditional salesperson license mentioned in the sources? Is there a specific renewal hurdle for that one?
Yes, there is. A conditional salesperson license is often issued before the applicant has finished all the required college-level real estate principal courses. If that license gets suspended because those courses weren't completed on time, you can only renew it by submitting proof to the DRE that you have now completed all those required college-level courses.
Okay.
And this must be done within 4 years of the original issue date of that conditional license. And just to be clear, these college courses are totally separate from the continuing education requirements for renewal.
Got it. Lots of rules and timelines to keep track of for licensing and renewal. Beyond just managing licenses, how does the DRE fulfill its public protection mission by, keeping the public informed about licensees?
Well, one key way the DRE provides public access to information is by posting disciplinary actions taken against licensees right on their website. This allows consumers to look up a licensee's history and see if there have been any formal actions taken.
So, transparency about discipline. The sources also mention a process where a licensee might be able to get that discipline notice removed from the website eventually.
Yes, that's mentioned. A licensee can petition the commissioner to have a disciplinary action removed from the DRE website, but there are conditions.
What are the conditions?
According to the source material, they can only file that petition after the disciplinary action has been posted on the DRE website for no less than 10 years.
10 years. That's a long time.
It is. And they have to provide compelling evidence of rehabilitation, essentially demonstrating that keeping the notice public is no longer necessary to protect the public from any credible risk associated with that licensee. The commissioner will look at various factors, including any subsequent violations, when deciding whether to grant that petition.
Interesting. So there's a potential path, to clear a public record after a decade of demonstrated good conduct. It kind of reflects a system that allows for both consequence and maybe rehabilitation.
Exactly. It seems to balance the need for enforcement and public notice with the possibility that someone can prove they are no longer a risk.
Okay, let's put on our agent hats for a minute. Think like an agent. Based on what we've just covered about the DRE, here's scenario one. You've sent your salesperson license application off to the DRE, everything's submitted. But a week later, you move, your mailing address changes. According to the DRE's process, what should you do?
Okay, based on the process described, you definitely need to inform the DRE about that change. The commissioner has the discretion to require you to submit a supplement to your application, specifically listing that updated address.
So don't just assume they'll find you.
No, definitely not.
Yeah.
You'd want to contact the DRE or probably use their online licensing system if possible to find out exactly how to provide that supplemental information promptly. You don't want your license or exam notice going to the wrong place.
Right. Timely updates are really important, especially when you're waiting for official notices. Okay. Scenario 2. You're a licensed individual broker, and you've decided you want to start operating under the name Ocean View Realty. You want your license to actually show that name. What's the sequence of steps you absolutely must follow with the county and the DRE?
Okay, first step. File the fictitious business name statement, the FBNS, with the county clerk in the county where your principal business address is located. Make sure you're listed as the registrant.
County first.
Once that's officially filed, get a copy, ideally a certified copy, proving it's filed. Then, you submit that copy of the filed FBNS to the DRE. You'll use the specific DRE change application form for an individual broker, adding a DBA, that's the RE204A mentioned, and you pay the necessary fee.
And then the DRE.
The DRE will process that application and the proof from the county. If everything is approved, they will issue your broker license showing Ocean View Realty as your DBA. Only then can you legally use that name for your business.
Filing with the county is the absolute necessary precursor to applying to the DRE for the license update. That sequence is key.
Got it. This deep dive into the DRE really shows it's so much more than just a licensing body. It's really the central player in maintaining standards across the board.
It really is. And everything we do as licensees operates within the framework that they establish and, importantly, enforce.
Agreed. Now, let's shift gears from the regulator itself to the rules they enforce. Segment 2. Essential laws and regulations. The agent's rulebook. What are the core legal principles and statutes that really guide an agent's daily activities in California? Well, the primary statute, the big one governing the conduct of real estate licensees in California, is simply called the Real Estate Law. You'll find it within the state's Business and Professions Code. It defines what constitutes licensed activity and really lays the groundwork for acceptable practice.
The real estate law. Okay. And those commissioner's regulations we mentioned earlier, how do they fit in with the law?
Think of the commissioner's regulations as the rules created by the real estate commissioner to interpret, implement, and basically provide more detail to the broader strokes of the real estate law. So if the law is kind of like the Constitution for agents, the regulations are like the implementing statutes and rules that explain exactly how the law is applied in everyday practice.
Got it. Law is the framework. Regulations fill in the specifics. Now, at the very, very core of the relationship between an agent and their client is this concept of agency. And with it comes a really heavy responsibility known as fiduciary duty. Our sources really hammer this home as fundamental.
They do, and for good reason, because it is absolutely fundamental. When a real estate licensee agrees to represent a principal, whether that's a buyer, a seller, a landlord, or a tenant, an agency relationship is created. Simple as that.
Okay.
And inherent in that relationship is a fiduciary duty that the agent owes to that principal. The sources even quote the Civil Code, describing this duty as one of utmost care, integrity, honesty, and loyalty.
Utmost care, integrity, honesty, and loyalty. Wow. That sounds like an incredibly high standard to meet. How do the courts typically view this fiduciary duty?
The sources emphasize that the courts have actually compared the fiduciary duty of a real estate licensee to the duty owed by a trustee to the beneficiaries of a trust.
Like someone managing a trust fund.
Exactly. Think about what a trustee does. They manage assets solely for the benefit of others, acting with the absolute highest degree of good faith and prudence. That's the level of trust and responsibility expected of a real estate agent towards their principal, their client.
Comparing it to a trustee really drives home the seriousness. Okay, so a real estate licensee typically acts as what the sources call a special agent. What does that term mean in this context?
A special agent is someone who's authorized to represent the principal, but only in a specific transaction or maybe a limited series of transactions.
Not everything.
No, not everything. A real estate agent is typically authorized to represent a buyer or seller just in the transaction of buying or selling a specific property, or maybe a borrower in negotiating a specific loan. They don't have general authority to manage all of the principal's affairs, only the defined task laid out in the agency agreement.
Okay, specific task. This often brings up the topic of independent contractors. We know many salespersons and broker associates are set up as independent contractors, usually for tax and labor law purposes. How does that status interact with this idea of being an agent and having that heavy fiduciary duty?
Yeah, this is a critical point, and it can definitely be confusing. The sources make it very, very clear. While a salesperson or broker associate might be classified as an independent contractor for certain purposes, like income tax reporting or workers' comp insurance.
Right, the IRS stuff.
Exactly. Meaning they aren't treated as a traditional employee for those specific things. They are still considered agents of the broker. And crucially, for dealings with the public, they are legally viewed as employees of the supervising broker.
Okay. So the independent contractor status for taxes doesn't let the broker off the hook for what the salesperson does?
Absolutely not. That's the key takeaway. The sources explicitly state that the independent contractor relationship for tax or labor law purposes does not in any way diminish the broker's supervisory responsibilities and liabilities for the conduct of the salesperson or broker associate when they're acting as agents dealing with the public.
So the broker is still liable.
The broker is liable for the actions of their agents in real estate transactions. This is a really key piece of public protection built right into the structure.
That's a vital distinction for everyone in a brokerage, broker, and agent alike to understand. What about mortgage loan brokers, MLBs? Are they also fiduciaries?
Yes, the sources confirm that. Real estate brokers acting as MLBs within the scope of their license generally must be agents and fiduciaries of at least one principal involved in that loan transaction.
Who's the principal, the lender or the borrower?
It could be either the lender or the borrower. And importantly, when they're dealing with private parties who are providing funds for loans or maybe purchasing notes, the MLB is considered a fiduciary of those private parties as well.
So whether you're representing a buyer or seller in a sale or arranging a loan, that fiduciary duty is almost certainly present. This leads us to a situation that requires really careful navigation. Dual agency. How is that defined in the sources, and what are the fundamental rules around it?
Okay, dual agency. It occurs when one agent acts for two or more principals in the very same transaction. The sources describe a couple of ways it typically happens. Either one licensee directly represents both the buyer and the seller, or maybe two different licensees, but they're from the same real estate brokerage, represent the buyer and the seller respectively. In that second scenario, the broker is the dual agent, representing both the buyer and the seller through their affiliated licensees.
Okay, so it's representing opposing parties in the same deal, either directly by one agent or through two agents in the same office where the broker is the dual agent. What makes dual agency so challenging, especially when you think about that fiduciary duty?
Well, the sources really highlight that the dual agent faces a unique challenge, maybe even an impossible one sometimes, in fulfilling the duties of loyalty and confidentiality to both principals at the same time. Because, their interests can conflict.
How so?
Well, think about it. Information that would really benefit one party, like maybe the lowest price the seller would take, might be confidential information owed to the other party, the seller. How do you handle that?
Yeah, that's a clear conflict of interest just baked right into the situation.
Yeah.
How does California law address this potential minefield?
The law demands absolute transparency and consent. An agent cannot legally act for two parties in a transaction where they have conflicting interests unless they have the full knowledge of both parties about the dual agency situation and, importantly, the informed consent of each party.
Knowledge and consent from both sides.
Both. And the sources stress this. Undisclosed dual agency is against public policy. It's grounds for rescission of the contract by any principal involved. And here's the kicker. They don't even need to prove they suffered any financial loss or injury.
Wow, just the fact it wasn't disclosed is enough.
Just the fact it wasn't disclosed properly is enough to potentially blow up the entire deal. Rescission, without needing to show harm, that's a powerful deterrent against trying to keep dual agency a secret. It really underscores how critical it is to be completely upfront.
Definitely. What about the scope of an agent's authority? The sources mention express authority and implied authority. What's the difference?
Express authority is exactly what it sounds like. It's the authority that is directly and clearly granted to the agent by the principal, usually spelled out in the written agency agreement, like a listing agreement or buyer representation agreement.
So, like, you are authorized to list my property for $500,000.
Exactly. That's express authority.
Okay, so what's implied authority then?
Implied authority isn't usually written down specifically, but it's the authority that is reasonably necessary for the agent to carry out the express authority and achieve the overall objectives of the agency.
Can you give an example?
Sure. If your express authority is to list and sell a property, your implied authority might include things like placing advertisements, scheduling showings, negotiating terms within the parameters the seller gave you, and handling the necessary paperwork, because those actions are reasonably required to get the job done according to the contract.
Okay, so express is the main instruction. Implied is what's reasonably needed to make that main instruction happen. What other duties does an agent owe their principal beyond those big four?
Well, beyond loyalty, confidentiality, and obedience to lawful instructions, the sources also mention the agent's duty to use reasonable care and skill in performing their duties, and also to render an accounting of any funds handled on behalf of the principal. That standard of utmost care, integrity, honesty, and loyalty applies to your principal, your client.
And what about the other party in the deal? The one you don't represent?
For the party the agent doesn't represent, the duty is generally described as one of honesty, fair dealing, and disclosure of known material facts about the property. It still requires reasonable care and skill, but it's not that higher fiduciary standard owed to your own client.
Right, a different level of duty. What about agents who aren't getting paid? Like, say you're helping a friend out for free. Are they still considered fiduciaries?
That's a good question. Yes, the sources clarify that as someone undertakes to act as an agent, even if they aren't getting compensated, they call this a gratuitous agent, and they actually start performing the work, they are still bound by the fiduciary duty of utmost good faith in their dealings with the principal.
So even helping out for free creates that duty once you start acting.
Once you start acting as their agent, yes. While they probably can't be forced to start the work if they aren't getting paid, once they begin, the duty applies.
That adds another interesting layer. Even just helping out can create a serious fiduciary responsibility once you start acting in that agent capacity. Now, let's touch on liability. When could an agent potentially be held personally liable in a transaction?
The sources discuss a couple of key situations where that might happen. One is if an agent enters into a contract on behalf of a principal, but they actually lack the authority to do so.
You weren't authorized.
Right, and they don't have a good faith belief that they did have that authority. In such a case, the agent could potentially be held personally liable for the performance of that contract they signed without permission.
So if you sign something on behalf of a client without the proper authorization or without reasonably believing you had it, you might be on the hook yourself personally.
Exactly. Another situation mentioned is if the agent fails to disclose to the third party that they are acting on behalf of a principal, or if they fail to reveal the name of that principal.
Like acting secretively.
Sort of. If the third party doesn't know there's a principal involved, they might reasonably think they're contracting with the agent personally. The sources suggest that in California, even if the fact of agency is known, if the principal's name isn't actually disclosed and listed on the contract itself, the agent can still be held personally liable.
So how do you avoid that?
To avoid personal liability for the contract itself, the principal's name must appear clearly on the face of the agreement.
That's a crucial practical takeaway. Always clearly identify the principal on the contract to avoid any unintended personal liability.
It's a really simple step, but it reinforces exactly who the parties to the agreement truly are.
This whole dive into agency and fiduciary duty, it really feels like the moral and legal backbone of the entire profession, doesn't it?
It absolutely is. Think of it as the ethical compass for real estate practice. It truly is the foundation upon which all the specific rules are built. Understanding that you owe your principal utmost care, integrity, honesty, and loyalty should guide your behavior in every single situation.
Especially tricky ones.
Especially when potential conflicts of interest pop up, like dual agency or maybe recommending services where you have some kind of stake. These duties demand transparency, full disclosure, and always prioritizing your client's interests above your own. It's fundamentally how you build trust and maintain your integrity in what can be a very complex environment.
Yeah, it's not just about getting the deal done. It's about doing it ethically and responsibly.
Precisely. Your reputation as a trusted advisor really hinges on upholding these core principles day in and day out.
That brings us logically to segment 3, handling money trust funds. If there's one area where trust and absolute precision are paramount, it's got to be dealing with other people's money.
You are absolutely right. Handling funds like earnest money deposits, maybe security deposits, or rent payments that belong to clients or other parties, this is one of the most critical responsibilities a real estate licensee has. And the DRE has very strict regulations governing these trust funds.
Okay, what's the most fundamental rule for handling these kinds of funds?
The absolute fundamental rule is that funds belonging to others must be kept separate, distinct, and apart from the broker's own personal funds or their business operating funds. This is the strict prohibition against commingling, and violating it is a very serious offense.
Don't mix client money with your own. Got it. Where exactly should these funds be deposited, and how quickly does that have to happen?
Okay, trust funds must be deposited into a designated trust fund account. This account has to be held in the broker's name or their fictitious business name if that's how they're licensed, and it must be clearly identified as trustee.
As trustee, okay.
This account has to be at a bank or another recognized financial institution. And the deposit, it must be made no later than the next business day following receipt of the funds by the broker or their salesperson.
Next business day. Wow, that's a tight deadline. Is there any exception to that, maybe for brokers who are handling escrow directly?
Yes, there is a specific exception outlined for brokers who are not licensed under California's separate escrow law, but find themselves acting as an escrow holder in a transaction where they're also performing licensed real estate acts.
Okay, what's the rule then?
In that specific scenario, the sources say the funds must be placed either directly into the hands of the owner of the funds or into a neutral escrow depository or into that broker's trust account, in their name as trustee, at a bank or financial institution, no later than the next business day following receipt. So while the options for placement are slightly expanded in that specific escrow context, the urgency to deposit promptly by the next business day still remains.
Okay, so typically into the broker's trust account, clearly marked as trustee by the next business day. What about interest-bearing trust accounts? Can brokers use those? Is that allowed?
Yes, they can, but there are specific conditions attached. If a trust account is set up to earn interest, the sources require that all funds in that account must be covered by insurance provided by a U.S. government agency, like the FDIC.
Okay, must be insured.
Must be insured. The funds still have to be maintained separately from the broker's own funds, of course. And importantly, the broker must disclose certain things to the party who's depositing the funds and to any known beneficiary.
What kind of disclosures?
They need to disclose the nature of the account, that it's interest-bearing, how the interest will be calculated and eventually distributed, how any service charges will be handled, and any potential penalties if the funds are withdrawn early. Full transparency about the interest is key.
Full disclosure about the interest makes sense. How is money withdrawn from a trust account? What are the rules there?
The sources are very strict here, especially when the broker is acting as an escrow agent. Money can only be withdrawn from a trust account with the written instruction of the party or parties who originally paid the money into that account.
Written instructions specifically from the source of the funds. That makes sense for security and creating a clear audit trail. Now, you mentioned avoiding commingling mixing funds. Are there any situations, any exceptions at all, where a broker's personal money is allowed to be in the trust account?
Yes, but these are very limited and very specific exceptions. They're designed not to be loopholes for general commingling. The sources allow a broker to keep up to $200 of their own personal funds in the trust account.
Only $200. Why?
Solely to cover legitimate bank service fees or charges related to that specific trust account, like maybe check printing costs or fees for insufficient funds, if those fees are being paid directly from the trust account itself. However, the sources actually note that the preferred practice is for the bank to be authorized to debit the broker's separate personal or business operating account for these service charges, not the trust account.
Okay, so $200 max for bank fees is technically allowed, but it's better practice to pay those fees from a separate personal or business account anyway. What's the other limited exception?
The second exception relates to commissions, fees, and other income that the broker has actually earned, and that is collectible from funds held within the trust account. These earned funds may remain in the trust account, but only for a period not exceeding 25 days after they are earned.
Okay, so earned commissions can sit there for up to 25 days.
Correct. But there's a crucial detail the sources emphasize here.
Yeah.
You cannot take out that earned income before the funds from the transaction have actually been deposited into the trust account. The money must be received and deposited first.
Makes sense.
And even when you're drawing out earned income that's legitimately yours, a broker cannot pay their personal bills or their business operating expenses directly from the trust account, even if the money is earned to commission sitting there.
Wait, really? Even if it's earned money?
Yes. The broker must first write a check from the trust account to themselves, or their brokerage operating account, for the amount of earned income they are withdrawing. They need to ensure that withdrawal is properly documented in the trust account records, and then deposit that money into their separate personal or business operating account before they use it to pay any personal or operating expenses.
Wow. That's a really important procedural detail. You can't just pay your office rent or your electric bill directly from the trust account, even if you know you have earned commission in there covering it. You have to physically move the earned money to your operating account first via a check to yourself.
Exactly. It maintains the absolute integrity of the trust account as a separate repository purely for client and third-party funds. Even for that brief 25-day period, earned income is allowed to remain. It keeps the accounting clean.
What kind of record keeping is required for these trust funds? It sounds like it needs to be meticulous.
Oh, it absolutely does. Brokers are required to maintain a separate record, often called a ledger or journal, of the receipt and disposition of all trust funds received. This record must document where the money came from, when it was received, where and when it was deposited, and exactly how and when it was disbursed.
So tracking every dollar in and out.
Every dollar. These records must show the transaction number or the names of the parties involved in the transaction and clearly identify each beneficiary and the exact amount being held for them. The sources also require a monthly reconciliation of the trust fund bank account records with the individual beneficiary or transaction ledgers, unless there was absolutely no activity during the month. And you have to maintain a record of that reconciliation as well.
Detailed ledgers and a monthly reconciliation. And I assume the DRE can check these records whenever they want.
Absolutely. Upon request of the commissioner, a broker must provide authorization for the examination of the financial records of their trust fund accounts maintained in any financial institution. This allows the DRE auditors to come in and verify compliance.
Makes sense. There's also a requirement mentioned for trust fund status reports, correct? Who has to file those?
Yes, brokers who meet certain criteria, usually based on the average balance or volume of activity in their trust accounts, must file trust fund status reports with the commissioner on a quarterly basis. These reports are typically due within 30 days after the end of each of the first 3 fiscal quarters.
Quarterly reports for brokers handling significant trust funds. What are the consequences if a broker fails to file these required quarterly reports on time?
The consequences can be quite severe, according to the sources. If a broker fails to file on time, the DRE is authorized to conduct its own examination and prepare a report on the broker's trust fund accounts. And they can charge the broker 1.5 times the actual cost of performing that examination and preparing the report.
1.5 times the cost. Ouch.
And it gets worse. If the broker then fails to pay that cost within 60 days of receiving the bill from the DRE, the commissioner can suspend the broker's license or deny its renewal. That suspension or denial stays in effect until the full amount charged is paid.
Wow. So failure to file the report can directly lead to losing your license until you pay a penalty charge for the DRE to come check up on you anyway. That really highlights how incredibly seriously the DRE views trust fund compliance.
They view it as one of the most critical areas of licensee responsibility.
Is there also an annual review requirement mentioned?
Yes, for brokers who hold trust funds, there's generally a requirement for an annual review of the trust fund financial statements conducted by an independent public accountant, CPA. This review confirms that the broker is maintaining the required records and that their trust fund bank accounts are being held and maintained in compliance with the commissioner's regulations. The accountant then submits a report of this review directly to the DRE.
So detailed internal records, quarterly reports for some brokers, and an annual external accountant review. It's a pretty comprehensive system designed to ensure that money held in trust is truly safe and properly accounted for at all times.
It is. And, adapt and connect here. Beyond just meeting the legal requirements, being absolutely meticulous with trust funds is a fundamental way you build incredible trust with your clients.
How so?
Well, imagine you're a buyer handing over a significant earnest money deposit. You want absolute assurance that money is safe, handled correctly, and kept completely separate from the agent's or broker's operating funds. Knowing and following these rules allows you, as the agent or broker, to confidently explain the process to clients, manage their expectations, and demonstrate your professionalism and integrity.
Right. It prevents problems before they start.
Exactly. It prevents potential issues that could range from just uncomfortable questions all the way up to serious disciplinary action. It cements your reputation for integrity and careful handling of their money.
It's really a tangible way to show clients you're serious about protecting their interests above all else.
Absolutely. It's truly foundational to being seen as a trusted advisor, not just a salesperson.
That brings us to segment 4, special California regulations specifically focusing on subdivisions and timeshares. These seem like areas where California has its own very specific rule book, again, designed primarily for consumer protection.
They absolutely do. California has distinct laws aimed squarely at protecting buyers and lessees when they're dealing with interest in subdivisions and timeshare plans. And yes, the DRE plays a key role in enforcing these specific rules as well.
Okay, let's start with the subdivided lands law. What's its main purpose? Why does it exist?
This law, which you'll find in the Business and Professions Code, governs the public offering of lands that have been divided into multiple parcels or lots. Its primary purpose is clear: consumer protection. It's designed to ensure that potential buyers or lessees receive essential, accurate information about the property they are considering purchasing or leasing within a development project.
And the key document generated under this law is called the public report. What kind of information does that report contain, and why is it considered so important?
The public report is issued by the real estate commissioner specifically for a subdivision. It provides prospective buyers with crucial factual details about the subdivision. Things like information about the land itself, any proposed improvements, the status of utilities, access roads, financing arrangements the developer might have, and any restrictions on use, like CC&Rs, covenants, conditions, and restrictions.
Okay, lots of key details. Why is getting it to the buyer so critical?
Its importance really cannot be overstated. The sources explicitly state that a subdivider, or their agent, cannot legally sell, lease, or even offer to sell or lease lots or parcels in a subdivision that requires a public report until the prospective purchaser or lessee has physically received a copy of that report and has signed a receipt confirming they received it and had the opportunity to read it.
So you absolutely, positively must get the public report into the buyer's hands and get their signed receipt before you can even accept an offer or take any money from them for that property.
Precisely. It's a mandatory disclosure requirement. It's designed to ensure the buyer is reasonably informed about the nature of the property and the development before they make any commitment. No report, no deal.
What's the process for a developer or a subdivider to actually obtain one of these public reports from the DRE? It sounds involved.
It is a multi-step process. It typically starts with a subdivider filing a notice of intention with the DRE, unless the subdivision happens to qualify for a specific exemption, which we can discuss.
Okay, notice of intention first.
Right. Along with that notice, they have to submit a very detailed questionnaire provided by the DRE and pay the associated filing fees. These fees can vary depending on the type and size of the subdivision being offered.
Then the DRE reviews everything.
Yes, the DRE reviews the entire submission against specific legal and regulatory criteria. The sources actually detail certain timeliness requirements for this review process. For example, the DRE has to notify the applicant within 10 days of receiving a resubmitted application whether it's substantially complete regarding the quantitative requirements, like having all the necessary documents.
Okay.
Then, for the qualitative requirements, which involves the DRE actually pointing out any deficiencies or inadequacies in the disclosures or setup, they generally have 60 days for standard subdivisions, or a shorter 20 days for certain types of residential subdivisions, after they've deemed the application quantitatively complete. It's a process with statutory timelines aimed at keeping things moving, but it can take time.
Yeah, it sounds like a detailed back and forth process is possible. You mentioned exemptions from needing to file that initial notice of intention. What kind of offerings might be exempt from the get-go?
The sources list specific conditions under which a proposed offering of subdivided land might be exempt from that notice of intention requirement. It's fairly narrow. Key factors include things like compliance with certain financial provisions designed to ensure completion of promised improvements.
Makes sense.
The land not being subject to certain complex definitions of subdivision, like those involving undivided interests or timeshares, which have their own rules, being located entirely within a city's boundaries. And crucially, each lot being sold or offered for sale must already be improved with a completed residential structure and have all the necessary infrastructure, like utilities and roads, ready for occupancy.
So basically finished homes in a city.
Generally, yes. Or if the structure and improvements aren't fully completed yet, there must be adequate financial arrangements already in place to absolutely guarantee their completion. It's mostly aimed at exempting standard, completed housing tracts within cities from the full subdivision review process.
Okay, so primarily, if it's fully improved residential property within a city, it might be exempt. But the specific legal criteria have to be met. What about conditional public reports? Are those issued sometimes before the final one is ready?
Yes, the commissioner does have the authority to issue a conditional public report if all the requirements for a final report aren't quite met yet, but it looks like they are likely to be satisfied soon.
But there must be catches, right?
Oh, yes. These conditional reports come with significant limitations. They must contain specific, prominent statements clearly indicating that it's only a conditional report, that it expires on a certain date, and that no sales can actually be closed, nor can any funds be released from escrow unless it's permitted by the specific conditions stated right there in the report. And the buyer still has to sign the required receipt for the conditional report and usually an additional statement acknowledging the conditions.
So even with a conditional report, the buyer absolutely must receive it and acknowledge it, and the deal can't close until the conditions are met or the final report is issued and received. How long is a conditional report typically valid for?
A conditional public report has a pretty limited term. It cannot exceed 6 months. However, the commissioner does have the discretion to renew it for one additional 6-month term if they determine that the requirements for issuing a final public report are likely to be met within that renewal period.
6 months, with one possible 6-month extension. And for both conditional and the final public reports, the subdivider or their agent needs to keep those signed receipts from the buyers, correct? How long do they need to hold on to those?
Absolutely. The requirement is very clear. They must retain each signed receipt for a public report for a period of 3 years from the date the receipt was actually taken from the buyer.
3 years.
3 years. And these signed receipts must be made available for inspection by the DRE upon request during regular business hours.
3 years for those receipts. That's a pretty long time, really emphasizing their importance as proof that the required disclosure was made. How is advertising for subdivisions regulated? Are there rules about what developers can say?
Yes. Advertising for the sale or lease of subdivision interests is also subject to DRE oversight. The ads must meet the commissioner's standards, and crucially, they cannot be false, untrue, or misleading in any way. A specific rule the sources mention is that the advertising cannot apply a use for a subdivision interest that wasn't actually set forth in the notice of intention and questionnaire that was submitted to the DRE to get the public report in the first place.
So the advertising has to be consistent with the approved plan and the disclosures submitted to the DRE. You can't promise something in an ad that wasn't part of the official filing.
Exactly. It must be consistent with the information provided to the state and what's contained in the public report itself.
Okay, now moving on to timeshare plans. The sources reference the Vacation Ownership and Timeshare Act of 2004. Does this law only apply if the actual timeshare property is physically located in California?
CA Corner. This is a really key point about California's specific approach to timeshares. No, the Act actually has a much broader reach than just property located here.
How so?
It definitely applies to timeshare plans where the property is in California. But it also applies to timeshare plans that have no property or component sites in California at all if those plans are being sold or offered for sale to any individual who is located within California at the time of the offer.
Wow, that's a significant regulatory reach. So if they're marketing to Californians, even for a timeshare in Mexico or Hawaii, this California law applies.
Generally, yes, it covers sales to California residents, regardless of where the timeshare property itself might be located. It's about protecting California consumers.
What kind of responsibility does the developer have under this act?
The Act places pretty significant responsibility squarely on the developer. They are required to supervise, manage, and control all aspects of the offering of the timeshare plan. That includes everything from promotion and advertising to contracting and closing the sales.
So the buck stops with the developer.
Pretty much. The developer is held responsible for the registered plan and for the actions of any sales or marketing entities they might use to sell the timeshares.
Is a public report required for timeshare plans similar to subdivisions?
Yes, a timeshare public report is also required. And similar to subdivisions, applicants for a timeshare public report must provide evidence that the accommodations are suitable and ready for occupancy, or that adequate financial arrangements are firmly in place to guarantee their completion or necessary renovation.
Okay. And what about timeshare plans that involve multiple locations or sites, like the point systems where you can stay in different places? Are there specific disclosure requirements for those complex plans?
Yes, absolutely. The sources list detailed requirements for disclosures that must be included in the public report for these multi-site timeshare plans. This includes things like describing any rights the developer might retain to add, substitute, or even remove accommodations or entire sites from the plan, explaining the purchaser's liability for any fees associated with the overall multi-site network or exchange program, detailing the location and description of each component site, providing historical occupancy data for the sites, if it's available, and describing how the reservation system works and how it might be adjusted based on usage patterns or demand across the different sites.
So a lot of transparency about how the whole multi-site system actually functions is required.
Exactly. It's aimed at making sure buyers understand the flexibility, but also the potential limitations or changes in a points-based or multi-location plan.
What about the homeowner association HOA aspects? Specifically, assessments or dues in these timeshare plans. Are there rules about increasing them? Because you hear stories.
Yes, there are specific rules. First, assessments against owners in a timeshare plan must be equitably apportioned among all the owners, and the sources detail specific rules about assessment increases. The governing body, usually the board of the HOA, can increase the regular annual assessment per timeshare interest by up to 20% compared to the previous year without needing a vote of the members.
Up to 20% without a vote. Okay.
However, if they want to increase assessments by more than 20% in a single year, it requires the vote or written approval of a majority of the voting power of the association residing in members other than the developer.
Ah. So the developers' votes are specifically excluded when determining if that over 20% increase gets approved by the owners.
Exactly. That's a key protection highlighted in the sources. It's designed to prevent the developer, who might still control a lot of votes early on, from unilaterally imposing huge assessment increases on the individual owners.
That makes sense. Is there any exception to that 20% rule?
Yes, there's one specific exception mentioned. An increase that is solely due to an increase in the real property taxes levied against the timeshare accommodations doesn't count towards that 20% limit requiring a vote. So if property taxes go up significantly, assessments can rise to cover that without triggering the owner vote requirement.
Okay, a specific carve-out just for property tax increases. What about the governance of the timeshare association itself? Things like member meetings, quorums, electing board members.
There are rules there, too, aimed at owner participation. The bylaws must set a quorum for member meetings at not less than 5%, nor more than 33 1/3% of the voting power of the association residing in members other than the developer.
There it is, again, specifically factoring out the developer's voting power for setting the quorum.
Yes, it's a recurring theme. And to ensure non-developer owners actually get representation on the board, especially early on, the rules state that as long as the developer holds a majority of voting power, or while there are different classes of membership, like developer versus owner, at least 20%, 1/5 of the members of the governing body must have been elected solely by the votes of owners other than the developer.
So owners get guaranteed board seats.
Guaranteed seats. And furthermore, those non-developer elected board members can only be removed from the board by a simple majority vote of the voting power residing in members other than the subdivider, the developer.
These governance rules seem very clearly aimed at giving the non-developer owners a guaranteed voice and some real protection within the association structure, even when the developer might still technically control a majority of the overall votes.
They really are. They're designed to ensure the interests of the individual owners are represented and can't be completely overridden, especially during that phase, while the developer still has a significant stake or control over the project.
Now, what authority does the commissioner have if things seem to be going wrong? If activities related to subdivisions or timeshares appear to be non-compliant or maybe harmful to the public?
The commissioner has a very powerful enforcement tool available, the authority to issue an order to desist and refrain.
Desist and refrain? What does that do?
It's basically an order directing the person or the entity involved to immediately stop whatever activity is specified in the order. The commissioner issues it when it appears that the activity is being conducted in violation of the law or the regulations, or that it's likely to cause harm to the public if it continues. It's a cease and desist order, essentially.
Can someone who receives one of these desist and refrain orders challenge it, or is it just final?
No, they absolutely have a right to a hearing. Any person who is served with a desist and refrain order can file a written request for a hearing with the commissioner, usually within 30 days of being served, to contest the order.
And is there a timeline for that hearing?
Yes, the sources specify timelines designed to ensure due process isn't delayed indefinitely. The hearing must generally commence within 15 days of the commissioner receiving the request, unless the parties agree to a later date. And then, the commissioner must issue a formal decision within 30 days after the hearing is concluded. If these statutory timelines aren't met by the DRE, the order is automatically deemed vacated, meaning it's lifted.
Okay, so there's definitely a path to challenge the order, and the process is designed to be relatively quick to get a resolution.
Exactly. It provides due process, but includes specific deadlines to prevent someone's business activity from being shut down indefinitely without a timely review and decision.
CA Corner again. These specific laws for subdivisions and timeshares really highlight California's unique and often quite stringent approach to certain types of real estate development and sales, doesn't it?
It absolutely does. The Subdivided Lands Law and the Timeshare Act, with their detailed public report requirements, the DRE review processes, the specific criteria for exemptions, the strict advertising rules, and particularly those unique governance and assessment rules for timeshares. These represent a significant layer of state-level consumer protection that often goes well beyond general real estate agency law.
So knowing these details is critical for agents working in these specific niches.
Critical. It makes you the crucial link between these complex rules and the consumer's understanding. You're not just selling units, you're navigating a highly regulated environment specifically designed to safeguard buyers in these potentially complex transactions.
It really emphasizes that it's not just about selling, it's about ensuring compliance and protection within that specific California framework.
Exactly. You have to know these specialized rules.
All right, let's apply this again with a think like an agent scenario. Scenario one, you're working with a buyer who is incredibly excited about a specific lot in a brand new subdivision that's still mostly under construction. The developer tells you the final public report is expected to be issued by the DRE in maybe a few months. Can you go ahead and have your buyer sign a purchase agreement today and accept their earnest money deposit to lock it in?
Based on the subdivided lands law we just discussed, no, absolutely not. You cannot accept a written offer, nor can you accept any money towards purchasing a subdivision interest that requires a public report until that prospective purchaser has had the opportunity to actually read the report, whether it's the final report or an approved conditional report, and has signed the official receipt acknowledging they received it.
So even if they want to commit now.
Doesn't matter. Even if a conditional report is available, remember, there are often restrictions on releasing funds from escrow until the final report is issued and delivered anyway. The public report process must happen before any purchase commitment is formalized or money changes hands. Report first, then offer.
Report and signed receipt before the offer and the money. That sequence is non-negotiable.
Got it. Okay, scenario two. You are showing a client a timeshare interest in a resort. What is the one absolutely essential document you must provide to the buyer and ensure they acknowledge receiving before they make any kind of commitment to buy?
For a timeshare, you must provide them with the specific timeshare public report for that particular timeshare plan. And just as critically, you must obtain their signed receipt confirming that they have received it and had the opportunity to read it. It really mirrors the subdivision requirement informed consent, documented via receipt of an official public report, is absolutely paramount before the sale can proceed. The public report is the absolute key for both subdivisions and timeshares, serving as proof that the buyer received the necessary detailed information before buying. These regulations really put the burden on the agent and the developer to make sure that disclosure happens correctly.
That's exactly right. It's proactive consumer protection mandated by law.
Okay, moving into segment 5, discipline and ethical breaches. We've talked about the DRE's role as the regulator and enforcer, and we've talked about the high bar set by fiduciary duty. Now, let's connect those dots by looking at the specific types of conduct that can actually lead to an agent-facing disciplinary action from the DRE, potentially even losing their license.
Right. The commissioner, as we said, holds significant authority to investigate the actions of licensees and, ultimately, to suspend or even revoke licenses if warranted. They also have the power to deny a license application in the first place if they find the applicant doesn't meet the required standards of honesty and truthfulness.
How do they assess that?
Well, the sources mentioned that fingerprint records are used to screen applicants for criminal history. And in some cases, the DRE might conduct formal hearings specifically to assess an applicant's character and truthfulness, especially if there are red flags in their background.
So the DRE screens people coming in and also monitors conduct throughout an agent's career. Where in the law do we actually find the specific list of things that can get an agent into trouble, the grounds for discipline?
The primary grounds for disciplinary action against licensees are found in two key sections of the Business and Professions Code, Sections 11176 and 11177.
1176 and 17877. Is there a difference between them?
Yes, there's a general distinction the sources point out. Section 10176 generally applies to misconduct that occurs while the licensee is acting as an agent in a specific real estate transaction. Section 1177 lists grounds for discipline that can apply more broadly, sometimes even for conduct that didn't happen directly within an active agency relationship, although many provisions in 10177 still relate to activities connected to the real estate business in some way.
Okay, so 100-176 is more about conduct during a deal as an agent, and 100-177 covers a potentially wider range of issues, maybe even things done outside of a specific transaction. Can you give us some concrete examples of violations listed in the sources that fall under these sections?
Certainly. A really significant one mentioned is the failure to disclose an ownership interest. This is key. If a licensee, or their relative, or even a close acquaintance, or any entity in which the licensee has a significant ownership interest, holds an ownership stake in a property that is the subject of a transaction where that licensee is acting as an agent for the buyer, the licensee must disclose the nature and extent of that ownership interest to their buyer principal.
So, failing to tell your buyer client that you or maybe your spouse or business partner actually owns the property they're thinking of buying, that's a big no-no you absolutely have to reveal.
It's a direct violation of the core duty of loyalty and transparency. Failing to disclose that is grounds for discipline. Another example given is violating specific articles or sections of the real estate law itself, or certain sections of the civil code that relate to mortgages.
Like some of those specific loan rules or disclosure requirements we touched on earlier?
Precisely. For instance, knowingly making a false or misleading representation to a seller who is carrying back a loan for a buyer specifically, a representation about the buyer's ability to actually repay that seller financing is explicitly listed as grounds for discipline under 1177.
So, you absolutely cannot misrepresent the buyer's financial situation to a seller who is essentially acting as the bank for them.
Correct. It's about protecting that seller from being misled into a risky financing arrangement based on false information from the agent. The sources also list making additions to, deletions from, or alterations of any instrument, like a purchase contract or escrow instruction, after a party has already signed or initialed it, without that party's knowledge and express consent. That's another clear violation.
Wow, changing the terms of an agreement after it's been signed behind someone's back. That seems like a fundamental breach of basic integrity.
It absolutely is.
Yeah.
Another one mentioned is making representations about the market value of a property that is securing a promissory note without having a reasonable basis for believing that representation is actually true and accurate.
So, you need a solid foundation, some kind of factual basis for any valuation claims you make, especially when those claims relate to the security for a loan. You can't just pull numbers out of thin air.
Exactly. You need a reasonable basis. And another important one, failing to disclose to your principal any significant interest you might have in a particular entity when you recommend using that entity's services or products.
Okay, so if I suggest my client use a specific pest control company or maybe a home warranty provider, and I happen to own part of that company, or maybe get a referral fee from them, I need to tell my client about that connection.
According to the sources, if you have a significant interest in that entity, or presumably a referral arrangement that could be seen as a conflict, and you recommend its services to your principal, that disclosure is required. It allows the principal to make an informed decision about using that provider, fully aware of your potential conflict of interest.
That ties directly back to that fiduciary duty of honesty and avoiding undisclosed conflicts. The sources also include some specific examples related just to mortgage loan activities, right?
Yes, for example, it is listed as grounds for discipline if a licensee knowingly misrepresents to a prospective borrower, or maybe to someone who is selling a promissory note, that there is an existing lender ready to make the loan or an existing purchaser ready to buy the note, when that's not actually true.
And why would they do that?
Usually with the purpose of inducing that person to use the licensee's services to arrange the loan or sell the note. Basically lying about having a buyer or lender already lined up just to get their business.
Got it. Lying about having a taker for the loan or note just to secure the client that's explicitly prohibited and can lead to discipline.
It is, as it's clearly a form of misrepresentation used to secure business unfairly.
Ethical compass. How do these specific grounds for discipline really reinforce that broader ethical framework, that fiduciary duty standard we discussed earlier?
Well, these listed violations are really just concrete examples of what it looks like to breach those core fiduciary duties of utmost care, integrity, honesty, and loyalty. Failing to disclose an ownership interest or a significant interest in a recommended company, that directly violates loyalty and honesty. Altering documents after signing or making false representations about a buyer's finances, that clearly violates integrity and truthfulness.
So the rules make the abstract duty concrete.
Exactly. These rules are the DRE's way of defining what specific unacceptable behavior looks like in actual practice. They particularly target actions that harm the public by undermining trust, creating undisclosed conflicts of interest, or involving outright dishonesty or misrepresentation. Understanding these specific grounds is absolutely essential for navigating your practice ethically and, frankly, for avoiding the kinds of pitfalls that lead directly to disciplinary action and potentially the loss of your license.
They really translate that high standard of fiduciary duty into specific actions you absolutely must avoid. What happens if the DRE investigates a complaint and actually substantiates charges against a licensee based on these grounds?
If the evidence supports the charges and the commissioner determines they are sufficiently serious, the potential consequences are significant. They include suspension or even outright revocation of the licensee's real estate license.
And if a license is revoked, is that it? Is that the absolute end of the road for their real estate career in California?
Not necessarily forever, but it's a very, very difficult path back. The law states that after a license is revoked, the individual affected cannot even apply for reinstatement for a period of at least 1 year from the effective date of the revocation.
Well, at least a year out.
Minimum 1 year. And the commissioner actually has the discretion to set a longer period in the revocation decision itself. And if they do, that longer period would apply.
At least a year before you can even ask to get it back. That's a significant consequence, clearly designed to protect the public. The sources also briefly mention criteria the DRE considers when evaluating rehabilitation, say, if someone with a past issue is trying to get a license or get one back.
Yes, when the DRE is evaluating whether someone is considered rehabilitated, perhaps after a criminal conviction, either in the context of a disciplinary proceeding or a license denial, they consider specific criteria that have been developed under the Business and Professions Code.
What kind of criteria?
These criteria might include factors like the nature and severity of the past act, evidence of remorse and change, restitution made, and also legal milestones, like whether the conviction has been expunged or pardoned, or if the individual has obtained a formal certificate of rehabilitation from the court.
So there's a formal process and a set of factors the DRE looks at when someone is trying to prove they are now fit and trustworthy enough to hold a license again after past issues?
Correct. It's all part of the process for assessing their present character and fitness to practice.
Okay, let's test our understanding again with a couple more think-alike-an-agent scenarios based on these grounds for discipline. Scenario 1. Your primary client is a buyer, and they are very interested in making an offer on a particular property. However, you recently inherited a small, let's say 10%, undivided interest in that specific property through a family trust. What does California law, as outlined in the grounds for discipline, specifically BNP 1A176, require you to do?
You absolutely must disclose your ownership interest in that property to your buyer principal. The sources are very clear. If the licensee, or their relative, acquaintance, or any entity they have a significant interest in, has an ownership interest in the property that your buyer client is pursuing, you have to disclose the nature and extent of that interest to your buyer client, fully and upfront.
Full disclosure of your personal stake to your own client is absolutely mandatory. Got it. Scenario 2. You are helping a seller evaluate an offer they received, and this offer includes seller financing. The seller is carrying back a note. You know the buyer's financial situation is actually quite weak, maybe precarious, but you're really eager to get this deal closed quickly. Are you allowed to tell the seller something like, oh yeah, this buyer has a strong ability to repay the loan, no problem, even if you know that's not really true?
Absolutely not. That would be a direct violation. The sources explicitly list knowingly making a false or misleading representation to a seller who is providing financing about the buyer's ability to repay that loan as grounds for discipline under BNP 10177. You cannot lie or mislead the seller about the buyer's financial capacity in that situation just to make the deal happen.
These scenarios really illustrate how those specific rules directly protect the public in this case. The buyer from an undisclosed conflict and the seller from being misled about financial risks and hold the agent accountable to that high standard of honesty and loyalty.
That's precisely their purpose.
Okay, let's move into segment 6, additional practice areas and regulations. We know California real estate involves more than just standard home sales. Our sources touch on several other areas that have their own specific regulations, and it's essential for agents who might work in these areas to know them.
Right. Let's start by revisiting mortgage loan brokerage, MLBs. We talked about the MLO endorsement, but beyond that, brokers involved in loan activities have some pretty detailed requirements, especially concerning record keeping and how they deal with private investors.
What kind of records are MLBs required to keep?
The sources state that real estate brokers acting as MLBs, those who arrange, make, or service loans secured by 1 to 4 unit residential properties, must maintain documents and records that are sufficient to enable the commissioner to determine if they're complying with all the laws and regulations.
So detailed enough for an audit.
Exactly. This includes, at a minimum, specific documents that are actually detailed right in the Business and Professions Code. And just like with trust funds, they must provide authorization for the DRE to examine these financial records upon request.
More stringent record-keeping and DRE oversight specifically for loan activities. The sources specifically mention MLBs using private money or private equity capital, meaning funds from individual investors, not banks. How does the law view those kinds of transactions?
Yeah, the sources include an important caution here. Just using the term private money doesn't somehow exempt MLBs from following all the applicable federal and state laws. While it's common industry jargon, the legal requirements remain unchanged.
Okay.
Importantly, California law generally treats transactions where MLBs arrange loans funded by private individual investors as securities transactions. Because the MLB is essentially facilitating an investment opportunity for that private party, they're often seen as acting in multiple roles simultaneously, maybe as the issuer of the security, as a brokerage and fiduciary to the investor, and potentially even as a de facto broker-dealer.
Wow, as securities. Because they're essentially setting up an investment for that private individual lending the money.
Exactly. And because of this classification, the sources strongly emphasize that specific disclosures are required for these private investors before the MLB commits the investor's funds to a particular loan or to the purchase of a promissory note.
What kind of disclosures?
These disclosures need to cover all material facts about the investment and, crucially, the associated risks. These are typically required under various sections of the Business and Professions Code and potentially even California's corporate securities law, unless a specific exemption happens to apply. The sources mention certain multi-lender or fractionalized loan arrangements that meet very specific criteria under Article 6 of the real estate law, might have slightly different rules, but generally, securities-type disclosures are needed.
So if you're a broker dealing with private investors funding loans, you have this whole extra layer of disclosure requirements, almost like you're selling stocks or bonds. That sounds complex.
It is a complex area, and it requires very careful compliance. The sources also mention a specific advertising rule just for MLBs. Any advertisement that's disseminated primarily here in California, promoting loan transactions or the sale of promissory notes secured by real property, must include the licensee's DRE license number clearly within the printed text or the oral script of the advertisement.
Your license number needs to be right there in the ad if you're advertising loans or notes. That seems clear and simple enough. Let's talk about advance fees. What's the rule around collecting fees from clients up front before the work is done?
This is another area with very strict consumer protection rules in California. Generally, MLBs and the MLOs working for them cannot collect an advance fee, which is defined as any fee collected before the services for which that fee is charged are fully performed unless there is a written agreement for that specific fee that has been previously reviewed and authorized by the Department of Real Estate.
Wait, the DRE has to approve the advance fee agreement before you can use it?
Yes, before you can even enter into it with a client. The only exception mentioned in the sources is for fees collected specifically for actual third-party credit reports or appraisal reports, but only if the fee collected is in the exact amount required by that third-party service provider. No markups allowed on those pass-throughs without the approved agreement.
So almost all advance fee arrangements need prior DRE approval before you can even agree to them with a client. What about advertising related to advance fees? If you have an approved agreement, can you advertise it?
Any advertising materials that you plan to use in connection with an approved advance fee arrangement also require prior approval from the DRE before you can use them. And, importantly, any advance fees received are considered trust funds and are subject to all the strict trust fund handling rules we discussed earlier, including the need for verified accountings to the client.
Okay, so DRE approval for the agreement itself, DRE approval for the advertising related to it, and strict trust fund handling for any money collected. That's heavily regulated, clearly to prevent abuse or consumers paying upfront for services they might not receive.
That's exactly the intent. It's designed to protect consumers from paying upfront fees, sometimes substantial ones, for loan modification or other services that might ultimately not be delivered as promised.
Now let's look quickly at regulations concerning the actual terms of loans themselves. Are there California limits on late charges for loan payments?
Yes. The sources state that for loans secured by real property in California, the charge imposed for a late payment of an installment cannot exceed an amount equal to 10% of the installment that was due.
Max, 10%. Is there a minimum?
Yes, there's also a minimum late charge allowed, which is $5. $5. That applies if 10% of the installment due happens to be less than $5.
Okay, max 10% of the payment with a $5 minimum floor. What about balloon payments? First, how are they defined, and what are the restrictions on them in California?
A balloon payment is defined in the law as an installment payment that is more than double the amount of the smallest installment payment required by the terms of the promissory note.
More than twice the smallest payment. Are they allowed?
There are restrictions, generally for certain types of loans, referred to in the sources as sheltered loans, that have a term of less than 3 years. Balloon payments are flat out not allowed. For loans secured by an owner-occupied dwelling, a balloon payment is generally not permissible if the total term of the loan is 6 years or less.
Okay, so limits on balloon payments based on the loan type and the term, especially for homes where the owner actually lives. Is there an exception to these balloon payment restrictions?
Yes, there's a notable exception highlighted in the sources. These restrictions generally do not apply to a promissory note given back to the seller by the buyer as part of the purchase price, what's commonly called a seller carryback loan, especially on a dwelling.
Okay, so seller financing is often treated differently regarding balloon payment rules. Got it. The sources also mention something called higher cost priced mortgage loans. What are these, and what are the implications of a loan falling into this category?
These are defined as consumer credit transactions that are secured by the borrower's principal dwelling, where the annual percentage rate, APR, exceeds a certain threshold compared to the average prime offer rate for a comparable transaction. Specifically, it's usually 1.5 percentage points higher for a first mortgage or 3.5 percentage points higher for a subordinate mortgage.
So loans with significantly higher rates, what happens if a loan is classified this way?
California law imposes specific limits on things like prepayment penalties for these types of higher cost loans. And the sources also warned that licensed professionals who, in bad faith, try to evade or violate the laws related to these loans through prohibited activities can face significant penalties.
What kind of penalties?
These can include actual damages awarded to the borrower, civil sanctions, disciplinary action against their license by the DRE, and even potentially criminal sanctions in egregious cases.
Wow, that really shows the seriousness with which predatory practices related to these higher cost loans are viewed in California.
It's definitely another layer of consumer protection, focusing specifically on potentially vulnerable borrowers who might be taking on higher cost loans.
The sources also briefly mention federal laws like TILA and Regulation Z and how California law aligns with them. What are these generally about?
TILA is the Federal Truth in Lending Act, and Regulation Z is the regulation that implements TILA. These are major federal consumer protection laws that require lenders to make very specific disclosures about the terms and, importantly, the costs of credit so consumers can compare offers.
And California law follows these.
Yes. The sources note that California law aligns with or directly incorporates aspects of TILA and Regulation Z, particularly for certain types of mortgage transactions. This includes those Section 32, high costs, and Section 35, higher price loans we just discussed, and the general category of higher cost price mortgage loans.
What kind of specific disclosures do TILA and Regulation Z typically require that borrowers receive?
Key disclosures include the finance charge, the total cost of borrowing, the annual percentage rate, APR, which reflects the cost as a yearly rate, the full payment schedule showing all payments, the total amount of payments over the life of the loan, details about any variable rate features, information about demand features where the lender can demand early repayment, and, very importantly, the borrower's right to rescind the transaction in certain circumstances. Regulation Z also has very specific rules about how credit terms can be advertised.
The right to rescind, the right to cancel the deal. That sounds like a big deal. What's the time frame for that right, typically?
For transactions that are subject to the right of rescission, like most refinances on a primary residence but not purchase loans, the borrower generally has 3 business days to rescind or cancel the loan. That 3-day clock starts ticking after the latest of these 3 events occurs. 1, the date the loan transaction is completed, consummation. 2, the date all the required material TILA disclosures are delivered to the borrower, or 3, the date the specific notice explaining the right to rescind is delivered.
3 business days from the latest of those 3 things. And what's a business day for this purpose?
For rescission purposes under TILA, a business day includes all calendar days except Sundays and federal legal holidays.
Okay, so a limited window, but a crucial one for borrowers to back out after getting all the key information. The sources also mention an expanded definition of who counts as a creditor under TILA now.
Yes, that's important. The definition of who is considered a creditor, and therefore subject to TILA's rules, has been expanded over time. It now includes any person or entity who originates just one high-cost mortgage, a Section 32 loan, or one reverse mortgage, or certain other specific types of loans like HOPA loans, even if it's done through an MLB or MLO within a 12-month period, or someone who originates two or more such loans directly without a broker.
So even originating just one of these specific types of loans, even if you use a licensed professional, can make that lender subject to all the TILA rules and disclosure requirements. That broadens the reach significantly.
It does. It means more lenders fall under the TILA umbrella.
What about affiliated business arrangement disclosures, or ABAs? What are those about?
Okay, an ABA disclosure is required if a creditor, a lender, or even another settlement service provider, like a real estate broker, refers a consumer to a specific other service provider, maybe an escrow company, a title insurer, or an appraiser with whom the referring party has an ownership interest, or some other affiliate relationship, like being parent subsidiary companies.
So if there is a business connection between the referrer and the company being recommended.
Exactly. If that connection exists, the affiliated business arrangement, ABA disclosure, is required. The sources state this disclosure must be delivered to the consumer at or before the time the referral is actually made. Or in some cases related to mortgage applications, it might be delivered at the time the good faith estimate, GFE, or loan estimate, LE, is completed and delivered.
And what does the lender or the referring party need to do after they give that ABA disclosure? Just hand it over.
They need to keep a record proving that the ABA disclosure was actually delivered to the consumer. If the disclosure was given during a face-to-face meeting, the lender or referrer must attempt to get a written receipt from the borrower acknowledging they received it.
What if the borrower refuses to sign the receipt?
If the borrower refuses to sign, the lender or referrer must simply make a note of that refusal in their business records for that transaction. And these records, proving the disclosure delivery or refusal to sign receipt, must be maintained for a period of 5 years after the transaction's execution date.
Attempt to get a receipt, document if they refuse, and keep those records for 5 full years. Again, detailed record keeping is a major recurring theme in all these regulations.
It really is. It's all about ensuring transparency and creating an audit trail, especially when there are potential conflicts of interest due to these business affiliations.
We touched on seller financing earlier regarding the balloon payment rules. Are there other specific disclosure requirements that come up with seller financing in California?
Yes. The sources mention that specific disclosure requirements are mandated for seller financing arrangements, particularly if the financing involves an all-inclusive deed of trust, which is sometimes called a wraparound mortgage.
Those sound complicated.
They are complex instruments, and the sources specifically advise licensees to only use all-inclusive deeds of trust, ATDs, with the advice of qualified legal counsel due to the potential risks and complexities involved. There are also required disclosures concerning the prompt recording of the security instruments, like the deed of trust, and the potential risks of intervening liens if those documents aren't recorded immediately after the note is signed.
So complex financing methods like ATDs come with extra legal caution flags and specific disclosure needs.
Absolutely, due to the significantly increased risk and complexity for all parties involved.
Okay, switching gears quite a bit. What about mobile home sales? Our sources note that real estate licensees can sell them, but only under very specific conditions related to their location.
Yes, CA corner again. This is another niche area where California law adds specific requirements. Real estate licensees are permitted to sell used mobile homes, but only if the mobile home is located in one of two specific types of situations.
What are the two situations?
Situation 1. It's already in place on a lot that is rented or leased for human habitation within an established mobile home park, and the sale is not contrary to the terms of the rental agreement between the park owner and the homeowner. Situation 2. It's located on a lot that is otherwise authorized by local zoning ordinances or permits for mobile homes' presence and used for a total and uninterrupted period of at least 1 year.
So it absolutely cannot just be any mobile home sitting anywhere. It has to be either in an established park on a long-term leased lot, and the park allows the sale,
Yeah.
or it has to be on a lot that's properly zoned or permitted for that mobile home's use for at least a solid year.
Correct. And the sources state very clearly that it is unlawful for a real estate licensee to even advertise a mobile home for sale unless it meets one of these specific location requirements.
That's a very specific California rule that might easily trip up agents coming from other states where the rules might be different. Finally, the sources briefly mention prepaid rental listing services, or PRLS. What are those?
Yes, these are basically services where a licensee provides lists of available residential rental properties to prospective tenants, usually for an upfront fee. This specific activity is regulated by the commissioner and requires a special PRLS license, which is separate from a standard real estate salesperson or broker license.
So another specialized license for that activity, CA Corner. This whole segment on additional practice areas really underscores how California has specifically tailored its real estate law to address particular types of transactions and potential consumer risks that might arise in those areas.
It really does. You see it from the detailed regulation of mortgage lending and the handling of private money with its intersection with securities law, to the very specific rules on things like advance fees, loan terms like balloon payments and high-cost loans, and even these niche areas like the specific location requirements for mobile home sales by licensees. These are all clear examples of the state identifying areas needing targeted consumer protection and specific integrity measures that go beyond the general real estate law that applies to all transactions. Mastering these demonstrates your depth as a true California expert.
It really highlights the importance of not assuming anything and really understanding these specific state-level nuances if you're working in these areas.
Absolutely essential for competent and compliant practice here in California.
Okay, let's apply this knowledge one last time with a couple more think like an agent scenarios. Scenario 1. A client comes to you and asks you to help them find a used mobile home to purchase. Before you can even agree to take on this client or start looking at or advertising any mobile homes for them, what is the absolutely crucial first thing you need to verify about any mobile home you might consider showing them or representing for sale?
The crucial first step, according to the sources we just discussed, is verifying its location status. You need to determine, is it currently situated in an established mobile home park on a lot that's rented or leased long-term? And does the park contract permit the sale? Or is it located on a lot that has been specifically authorized by local zoning or permits for that mobile home's presence and used for at least one uninterrupted year? You cannot legally handle the sale or even advertise it unless its location meets one of those specific criteria. Location, location, location is absolutely key for licensed mobile home sales in California. Got it. Scenario 2. You are working with a buyer who is in the process of getting a mortgage from a lender. During the process, the lender recommends that the buyer use a specific pest control company for their termite inspection. It turns out that your brokerage happens to own a significant percentage, say 25%, of that particular pest control company. What specific disclosure is likely required in this situation? This scenario sounds like a textbook example of an affiliated business arrangement, ABA. Since there's a referral being made by the lender, but the issue could arise if you made the referral to a service provider, the pest control company, with whom you, through your brokerage's ownership, have a business affiliation, an ABA disclosure would almost certainly be required. It needs to be delivered to the buyer at or before the time the referral is made, or perhaps with the loan estimate, disclosing that ownership relationship.
Disclosing that business link is absolutely key for transparency when recommending affiliated services. These scenarios really help bring the practical application of these specific regulations to life.
They do. It helps solidify why knowing the details matters.
All right, moving to segment 7, property characteristics and valuation basics. Now, while the main focus of this deep dive has really been on the legal and regulatory landscape, our sources did touch briefly on some fundamental concepts related to analyzing property and the basics of valuation. We're definitely not going to try and turn you into a certified appraiser today.
No, definitely not in this session.
But let's cover the basic valuation concepts that were mentioned in the material.
Okay. Well, the sources mention the importance of doing a proper site analysis when looking at a property. This includes fundamental things like determining the property's precise legal description. You get that from official records like the deed. That's absolutely fundamental to identifying exactly what property you're even talking about.
But the boundaries.
Exactly. They also briefly mention reviewing property taxes. Although they make a point of noting that California's Proposition 13, which significantly limits how much property taxes can increase each year, makes comparing taxes between different properties less straightforward than it might be in other states. Here, the tax bill is often more closely tied to the property's last sale price rather than its current market value.
Good point about Prop 13's effect on tax comparisons. So, legal description and understanding the tax situation are part of analyzing the site. What about the physical structure itself? What did the sources mention there?
The sources touch on the basics of evaluating the quality and condition of a property's physical structure. This involves looking at the key components, things like the foundation, the framework, wood, steel, the exterior and interior walls, the roof, condition, age, material, interior finishes, the plumbing and electrical systems, the HVAC, heating, ventilation, air conditioning, kitchen and bathroom features, insulation levels, and also ensuring there's adequate natural light and ventilation. It's really a basic checklist of the key structural and system components you'd look at.
So, knowing what major structural elements to inspect or at least ask about, the sources also outline the three standard approaches typically used in property valuation by appraisers.
Yes, the three common approaches mentioned are the sales comparison approach, the income approach, and the cost approach wasn't detailed as much in these specific sources, but they mentioned the final step of reconciliation.
Okay, let's start with the sales comparison approach. What's the underlying principle behind that one?
This approach is based fundamentally on the principle of substitution. The core idea is pretty simple. A prudent buyer wouldn't logically pay more for a property than it would cost them to acquire a reasonably comparable substitute property that offers similar utility and desirability.
Makes sense. How does it work in practice?
The process involves systematically gathering data on recent sales of properties that are considered highly comparable to the subject property, the one being valued. Comparability is judged based on factors like location, neighborhood characteristics, site features, size, topography, the size of the building, its age, style, overall condition, and sometimes even the financing terms involved in the comparable sales.
So you find recent sales of really similar properties nearby and then adjust their prices up or down based on minor differences compared to the subject property.
Exactly. You make adjustments for those differences. And the sources emphasize the importance of looking beyond just the final recorded sale price of the comparables. You need to try and understand if there were any concessions, unusual financing, or other influences that might have affected that reported price to make sure you're comparing apples to apples as much as possible. The more relevant and recent the comparable sales data you have, the more reliable your value estimate is likely to be using this approach.
Okay, that's sales comparison. What about the income approach? When is that used?
The income approach is primarily used for properties that generate income, think rental properties, apartment buildings, office buildings, retail centers. It's based on a different principle, the principle of anticipation.
Anticipation of what?
Anticipation of future benefits, specifically future income. The present value of the property is estimated based on the anticipated future income stream it's expected to generate over time. The process involves converting that anticipated future income into a present value, usually through a process called capitalization, using a capitalization rate or other methods.
So, valuing an investment property based primarily on its income-producing potential. The sources mentioned there can be different viewpoints on income property.
Yes, they highlighted the distinction between how a formal appraiser typically views income property versus how an individual owner might look at it. An owner might be focused on their personal equity in the property, their specific operating expenses, maybe their tax deductions, or the actual rent they collected last month.
Right, the owner's specific situation.
Whereas an appraiser, using the income approach, is typically trying to estimate the property's capacity to generate a market-level income stream based on prevailing market rents and typical operating expenses for that type of property, regardless of the current owner's specific management or financial situation. The sources also briefly mentioned the land residual technique as one specific method that can be used within the income approach framework, sometimes to estimate the value of the land itself based on the income that's attributable just to the land after accounting for the income generated by the building.
Interesting. Using the income to figure out the underlying land value in certain situations. What's the third part mentioned? Reconciliation. What happens there?
Reconciliation is the final step an appraiser performs, especially when they've developed value indications using more than one approach, like maybe sales comparison and income or sales comparison and cost. It's really important to understand that reconciliation is not just simply averaging the results from the different approaches.
So what is it then?
The appraiser weighs and compares the conclusions reached under each approach they used. They consider the type of property being appraised. Is it a house, an office building, a special use property, the quality and quantity of data that was available for each method, and which approach is generally considered the most reliable and relevant for that specific property type.
Can you give an example?
Sure. For instance, the cost approach, which estimates value based on the cost to build new, less depreciation, might be given more weight for a brand new building, where costs are easy to estimate and there's little depreciation. Whereas the sales comparison approach is usually considered the most dominant and reliable method for valuing single-family homes in an active market with lots of comparable sales. The appraiser uses their judgment and experience to reconcile the different value indications into one final supportable value conclusion.
Okay, so it's synthesizing the findings from the different methods using professional judgment to arrive at one final value estimate. Now, how does understanding these basic valuation concepts actually help an agent in their day-to-day practice, even if they aren't performing formal appraisals themselves?
Connecting to practice. Having even a basic grasp of these concepts is incredibly empowering for an agent. For sellers, it allows you to have much more intelligent and credible conversations about pricing strategies. You can explain how buyers and appraisers will likely look at their property, referencing comparable sales data and market trends.
And for buyers.
For buyers, it helps you analyze asking prices more effectively and formulate realistic offer strategies. You can help them understand how a property stacks up against recent sales and whether the price seems justified based on market data. While you won't be issuing certified appraisals, this knowledge gives you a solid framework and a professional language for discussing price, market conditions, and property characteristics with confidence. It makes you a much more knowledgeable and trusted advisor, rather than someone just guessing at prices.
Yeah, it provides a professional language and a logical framework for talking about price that definitely goes beyond just desk work or gut feelings.
Exactly. It's a key part of building your expertise and credibility with clients.
We have certainly covered a tremendous amount of ground today, navigating the often complex world of California real estate law, regulation, and related practices. Let's try to pull it all together now in Segment 8. Trust and integrity key takeaways. Let's just recap the major themes and points we've unpacked from the source material.
Okay, sounds good. We began with the California Department of Real Estate, the DRE, really understanding its crucial role as the primary regulator for the industry in the state. We saw its core mission as maximum public protection, and how that mission drives all its functions from licensing and enforcing the rules to overseeing specific areas like subdivisions and mortgage loan activities.
We then dove deep into the absolute core of the agent-client relationship, the concepts of agency and fiduciary duty. We really emphasized that incredibly high standard required by law, that duty of utmost care, integrity, honesty, and loyalty, and how the courts compared this duty to the responsibility of a trustee. This fiduciary duty, we saw, is truly the bedrock foundation for ethical practice.
Absolutely. Then we explored some really essential regulations, like the extremely strict rules for handling trust funds. We covered the absolute requirement for keeping client funds separate from broker funds, the tight next business day deposit timelines, the rule about withdrawals needing written instruction from the parties who paid the money, the very limited exceptions for putting broker funds into the account, and the detailed record-keeping, reporting, and annual review requirements designed to ensure accountability.
We also covered a whole range of specific regulations that impact daily practice. Things like advertising rules, remember needing license numbers and loan ads, and getting DRE approval for advance fee advertising, and those detailed loan and finance disclosures that are required.
Right. That included limits on late fees, the restrictions on balloon payments for certain loans, the specific rules and heightened scrutiny around higher-cost mortgage loans, and how California law aligns with federal TARILE and Regulation Z, requiring key disclosures like the APR, full payment schedules, the right to rescind in some cases, plus the specific requirements for making affiliated business arrangement (ABA) disclosures when referrals involve related companies.
We also make sure to highlight those uniquely California consumer protection laws like the Subdivided Lands Law and the Vacation Ownership and Timeshare Act. We saw how they mandate detailed public reports with specific content and strict delivery procedures before a sale can happen, and those unique rules for timeshare governance and assessments that are designed specifically to protect the non-developer owners. And we noted the commissioner's power to issue desist and refrain orders to stop violations in these areas.
And finally, we reviewed the specific grounds for disciplinary action found back in Business and Professions Code sections 10176 and 10177. We saw concrete examples of how actions like failing to disclose ownership interests or affiliations, making false representations, like about a buyer's ability to pay, or improperly altering documents after they're signed, are direct breaches of those ethical duties and can, unfortunately, lead to license suspension or even revocation.
It really is a comprehensive body of law and regulation designed to govern the profession here.
It is indeed.
And weaving through all of it, from the DRE's mission to the specifics of trust funds and disclosures, is that consistent underlying theme of consumer protection and maintaining the integrity of the real estate profession in California.
Absolutely. And that's the real takeaway, I think. Understanding and, more importantly, adhering to these laws and regulations isn't merely about passing an exam or just avoiding disciplinary action. It is fundamentally about building a career that is grounded in integrity and trust. These rules provide the essential structure that protects the public when they're involved in what are often very complex and high-stakes financial transactions. By mastering these rules, you demonstrate your commitment to ethical practice, and that's how you build confidence with your clients.
It really elevates the role beyond just being a salesperson, doesn't it?
Yes, exactly. This knowledge is truly the bedrock for becoming a genuine California real estate expert and, more importantly, a trusted advisor. It empowers you to confidently navigate complex legal and financial situations for your clients, to anticipate potential issues before they blow up, and to adapt to their unique needs and the constant challenges of the market, all while operating clearly within the bounds of the law and upholding the highest ethical standards. In a way, it transforms you into a safeguard for the entire transaction.
That shift in perspective you mentioned, from just being a salesperson to being a guardian of the transaction for your clients, that's really powerful when you think about it.
It truly is, and I think it's what distinguishes a merely competent licensee from an exceptional one here in California.
Okay, for our final segment, segment 9, provocative thought and next steps. Here's something for you, our listener, to consider as you digest all of this detailed information. Given the DRE's core mission, which we established is all about protecting the public, and given all these detailed regulations we've explored that govern licensee conduct rules about disclosure, handling money, advertising, agency duties, conflicts of interest, and so much more, how does your personal mastery of these rules fundamentally change your potential role? How does it shift you from simply being a salesperson aiming to close a deal into potentially being a guardian of the transaction for your clients?
It's a great question to ponder. Think about it. Each rule, each disclosure requirement we discussed, each restriction on certain conduct, it's essentially a protective layer designed for the consumer. By deeply understanding and then diligently applying these rules in your practice, you become the active implementer of those safeguards for your client.
Yeah, you become the person who ensures the client actually receives and understands the public report before they commit, or the person who guarantees their earnest money deposit is absolutely safe and accounted for, or the one who ensures any potential conflicts of interest you might have are fully disclosed so they can make an informed decision. You become their expert guide through all the legal complexities and potential pitfalls.
It really shifts the focus, doesn't it? From just making the deal happen to ensuring the deal happens correctly, ethically, transparently, and safely for everyone involved, especially your client, whose interests you have a duty to protect.
Right. A fundamental shift in perspective and responsibility. As for what's next on our deep dive journey using your sources, now that we've explored the regulatory landscape and the fundamental rules of conduct and agency, we'll turn our attention next time to the actual building blocks of every single real estate deal, the contract itself.
That's right. Next time, we'll dive into how real estate contracts are formed in California. We'll look at the different ways property can be owned, forms of vesting, and we'll explore the process of actually transferring title from seller to buyer, drawing again from the source material you provided on those topics.
Essential topics that build directly on the legal and ethical foundation we've laid down today.
Indeed. They're the next logical step.
So, as you continue your journey in mastering California real estate, we really encourage you to revisit your notes from this deep dive. Maybe spend some time exploring the DRE website, that's dre.ca.gov, looking up some of the forms or code sections we mentioned. And definitely think through those think like an agent scenarios we posed. Challenge yourself with how you would respond ethically and legally in those situations.
Keep learning, keep asking questions, keep integrating these principles into your thinking, and keep building that practice based on solid knowledge, integrity, and expertise.
Thank you so much for joining us for this deep dive into the essential legal landscape of California real estate. We truly hope this has provided valuable clarity and a sense of empowerment for your path forward in this exciting field.
Until next time, keep diving deep.